NACDL proudly presents Criminal Justice and the Media, a three-part series exploring how journalists can inform the public on the criminal justice system. Criminal Justice and the Media is generously supported by the Foundation for Criminal Justice and the Park Foundation.
I'm Ivan Dominguez, Director of Public Affairs and Communications at the National Association of Criminal Defense Lawyers, or NACDL. And today, we're going to explore the topic covering appellate decisions. How can journalists identify key appellate issues and effectively explain an often complex appellate process? How do they translate the key legal issues into terms that are readily understandable to the public? How do they effectively cover an appellate case and ultimately report and explain the real-life consequences of those appellate decisions? Today, we have with us two of the nation's most eminently qualified and seasoned journalists to tackle this subject with us. Adam Liptak, on my far left, covers the Supreme Court for the New York Times. Adam's column on legal affairs, Sidebar, appears every other Tuesday. Prior to joining the paper's news staff in 2002, Adam practiced law at a large New York City law firm and in the legal department of the New York Times. Adam was a finalist for the Pulitzer Prize in Explanatory Reporting in 2009 for American Exception, a series of articles examining ways in which the American legal system differs from those of other developed nations. And he received the 2010 Scripps Howard Award for Washington reporting for a 5-part series on the Roberts Court. He's the author of To Have and Uphold, the Supreme Court in the Battle for Same-Sex Marriage. His journalism has appeared in the New Yorker, Vanity Fair, Business Week, and Rolling Stone. Welcome, Adam.
Good to be here, Ivan.
And to my left, David Savage is the Supreme Court correspondent for the Los Angeles Times and for the Chicago Tribune, and has served in that role at the Times since 1986, prior to which he was the Los Angeles Times education writer based in Los Angeles. He's the author of Turning Right, The Making of the Rehnquist Supreme Court. In addition, David wrote a monthly column on the court for the American Bar Association Journal and offered regular legal commentary on National Public Radio's Talk of the Nation. Welcome, David.
Good to be here.
So I'd like to start with you, David. If you could tell us what you do and how you found your way to this beat.
Well, I'm sort of lucky to get to this beat. I thought covering the Supreme Court, when I started out in journalism, I didn't go to law school. I was interested in the law, but I didn't want to be a lawyer. So I got into journalism. And one of the things I learned, I started covering education, basically by happenstance. But I really liked covering stories that were big issues. Some people go into journalism and they're investigators. They really are sort of police and prosecutors at heart. They love to go out and investigate things. You also see journalists who are very good at people stories, profiling people, going out and covering politicians. I was one that I really enjoyed stories about big issues, public disputes about big public issues. Well, after I'd done journalism, after I'd done education for a few years, an opportunity came up to cover the Supreme Court. And the national editor in Los Angeles called me in and said, David, you write a lot of issue stories. I think you'd be very good at this. So I came back and started doing this in 1986. And for a journalist, there's some parts of covering the Supreme Court that are just terrific. Because some of the biggest issues in the country, affirmative action, abortion, gay rights, gun rights, they come to the Supreme Court. And there are also issues that are presented to the court where there's a real argument on both sides. There's good briefs. I don't think you have to be a lawyer, I didn't think so, to cover the court because actually there's sort of big social, political, legal issues where there's a very good argument on both sides. So from the very beginning, I just thought from the point of view of the journalist, it was just a wonderful way to write about a whole series of issues. And year to year, the other nice thing about the Supreme Court, they take on new questions and new issues, so it never feels like it's getting really boring. It's not like you're doing the same thing over and over again, because each year and each era, there's sort of a whole series of sort of new legal issues. So I just thought from the point of view of a journalist, it's a wonderful way, it's a wonderful beat, and it's a wonderful way to write about a whole series of important issues.
And Adam?
Well, so I completely agree with David that it's a neat beat because it's full of ideas and public controversies, and the materials are, and this is unlike most journalism, basically presented to you on a platter. You get excellent briefs, you go to the arguments, you see the justices in action, and you don't use the whole journalistic toolbox. You're not, for the most part, finding out secret stuff. You're not, for the most part, trying to scoop your competition, but you're trying to synthesize and analyze and explain sometimes difficult technical materials. And it is, for a journalist of a certain temperament, and I think David and I share it, a delight. And one reason that David has been on the beat so long, and so many of my colleagues in the Supreme Court have been on the beat so long, is because A, it's a pleasure, but B, it also is the sort of beat that rewards the journalist who's willing to stick with it, because you get better as you go along. And while David didn't go to law school, if all he does is for decades read briefs, go to arguments, read decisions, explain them, he's basically going to law school over and over again, because that's very much like what people do in law school.
Thank you. Adam, let's start with the basics for our audience. I want to know, how do you think about, when you're approaching a case, and just in general, how do you think about the American court system when you're doing it with the goal of explaining to people what's going on in that court system so that they can be an informed public?
So, Ivan, we're talking about the Supreme Court, which is an appellate court, which means it's not one of those courts you see on TV where there are jurors and witnesses. The Supreme Court and appellate courts really hear only legal argument. They hear a kind of debate. The facts are already fixed, they're agreed on, they're in the record, which is printed and distributed to the justices, and what they're interested in is resolving a difficult legal question. And so the task of the journalist is to bring that sometimes technical question to life for a reader who doesn't have training in the law and has some general sense, some intuition maybe about how they might think about a pressing social issue, death penalty, abortion, whatever. But you need to explain to them the precise legal issue the court is dealing with. And the best way to do it in journalism, sometimes available, sometimes not, is through the facts of the case. If you can get a case up on its feet through an anecdote, through a narrative, introduce the reader to the actual people involved, then it's much easier to lead them to the legal question involved, because they'll have a sense of what the stakes are.
Do you have anything to add to that, David?
Well, in covering the court, I always think there's a couple big issues that you can sort of write about and sort of explain to the public. I definitely agree with Adam that this is a different sort of beat in that we spend most of our time explaining what the justices are doing, explaining what they're deciding. I'd like to say, like with every time there's a decision of the court, there's like three different questions, like what did the court decide, what's the legal basis for the decision, and what's the significance, what does it mean? For a lot of law audiences, what they decide and what's the legal basis is really what lawyers are interested in. I think if you're speaking to a sort of a broad general public, the question is, what's the significance of this decision? When the Supreme Court decides something, what does it mean? What, for the average person who picks up a newspaper or these days, goes online and checks, what's the significance of the decision? And that's frequently very hard because the court is in the business of deciding legal questions. They frequently don't spend a lot of time explaining what does this decision mean. So I think one of the really challenging parts of the job is sort of explaining what they've decided and explaining what it seems, what it's likely going to mean.
That third or fourth paragraph in every good article, what are the consequences, is the hardest one to write. The easiest one to write, and sometimes we're criticized for this by the justices, is which side won, who lost. And they will often say that's not the point of the decision. They're not really interested in the who won, who lost in the particular case. What they're interested in is the general rule that they've announced that will apply to thousands of cases. And sometimes the justices will criticize us for putting in the second, third, or fourth paragraph the general legal principle that they've announced. And there's some truth in that. If you focus too much on whether David or Goliath won, you may lose the message of how is this going to play out among the hundreds or thousands of other cases that will follow in its wake.
So I want to start because obviously if you're covering the Supreme Court, you have necessarily an understanding of how cases have wound themselves up through the process, through our court system, through the appellate courts and up to the U.S. Supreme Court. So I want to ask a couple of questions that give our viewers an understanding of that process. And so I'd like to start with you, David. What are some of the particular features of a criminal case that comes before the court, and starting with the whole idea of what distinguishes them from a civil law case in terms of how one approaches them and what their implications are for the public?
Well, I'll just talk about the kinds of criminal cases that would get my attention, and there'd be some sort of criminal legal issue that, again, is going to have some broad impact. You don't want to write about a criminal case where somebody is convicted of a crime, and his basic argument is, oh, they didn't have enough evidence, I really was innocent. Those are not very good Supreme Court cases. They had one last year that Maryland versus King about the question of whether, if you're arrested for any sort of crime, can the police take a DNA sample from you, a mouth swab, and then possibly put it in a DNA database and charge you with a whole bunch of other, unsolved crimes. Now, there's a issue that has a lot of public resonance. I know in California, for example, they've been doing this for a while, and it happens over and over again that someone gets arrested for a breaking and entering, a burglary or something like that, and they put his DNA in and find that the person is, the suspect in a whole series of rapes or very serious crimes. So it's become, whether that was constitutional, whether that search is a very big question. So I must say, I sort of look for the criminal cases where there's a legal issue that's going to affect a whole lot of people and a whole lot of cases. And so when you see one of those coming up to the court, and it's usually a situation where the courts in California have said one thing and the courts in New York have said something else. That's also the reason the Supreme Court would jump on a case where something about the Fourth Amendment, where there's a division of opinion. So anyway, if I see a case like that coming, I will write about it, and Adam will write about it even before it gets to the Supreme Court, because you can see there's a sort of big legal issue there. It's going to have to be resolved, and how they resolve it is going to, have a broad impact.
And to step back just a little bit and give some context, when David talks about criminal cases, of course, he's talking about those cases where someone is subject to having their liberty taken away, being sent to prison, or someone is subject to being punished by the government by paying a fine or something. Those are the criminal cases, and that's maybe a little less than half the court's docket. On the other side are civil cases where people are suing each other, typically for money, and those are important cases too. But it's fairly hard to go to jail at the end of such a case.
And Adam, both of you had alluded earlier to the unique nature of what goes on in the Supreme Court as often a debate about the law. And I'm wondering if you could break it down into its most basic terms to explain to our audience what is the difference between what goes on at a criminal trial versus what is usually going on in an appeal of the outcome of one of those trials.
A lot of stuff goes on in a criminal trial. Evidence is presented, witnesses testify, jurors are present, they make judgments about credibility, there are motions about what evidence is admissible or not, and it's a rich stew of stuff. And at the end of that, there's an outcome. Let's say someone gets 5 years in prison. The appeal is much more finely focused. It typically involves one or two questions about, did the judge say, instruct the jury properly that if you show a gun while you're committing a crime, you may be subject to an additional punishment? And that narrow question goes up to an appellate court. And think of the legal system as a pyramid. So there's, say, a mid-level appellate court in the federal system. They're called circuit courts. In the state system, there are mid-level appellate courts, state Supreme Courts. At the very, very tippy top of that pyramid is the U.S. Supreme Court, which of all the hundreds of thousands of cases all over the country every year, about 8,000 of them reach the Supreme Court in the following limited sense. 8,000 times people ask the Supreme Court, please hear my case. I think I have an important legal issue that I'd like you, the Supreme Court, to decide. And of those 8,000, the Supreme Court agrees to hear maybe 80, maybe 1%. So that's a minuscule little place at the top of the pyramid. And the court basically is not interested in correcting injustices. It's not in the business of what it calls error correction. It's in the business of finding legal principles that the lower courts have divided on, that it's now going to settle for the nation, and it's now going to adopt a uniform rule for the whole nation in that minuscule group of 80 cases.
David, earlier you spoke about what it is that motivates you to focus on a particular criminal case. And I have to say, covering the Supreme Court, or for that matter, any court, is hardly a niche beat. I mean, the vast expanse of the human experience, from private disputes and public wrongs to property rights and free speech, all of these work their way into our courts. And once you've identified a criminal case that you believe merits your attention and the attention of your readers, where do you get started in learning about the issues in the case and the context in which the case has come before the court?
Well, as Adam suggested earlier, one of the great things about the court is that there are all these briefs that come into the court, and there are good lawyers on both sides, and frequently there are friend of the court briefs that sort of weigh in and say, here's an important issue. NACDL is one of them. It says, here's an important issue. You, the Supreme Court, ought to take this. So I do a lot of reading, and then there are a lot of lawyers that you can call or email and sort of talk about them. So I find, and also these days, it's also easy to find online a lower court opinion, sometimes to find other articles about this issue or, that explain it further. There's a lot of dispute now in the courts about cell phones. Whether the police can, if they arrest you, can they look into your cell phone? Or do they need a search warrant to do that? Well, you can read about that online. You can call people who've written about it, and you can call lawyers. So I find that once you get a interesting case or issue, it's not too hard to find a lot of people. That's one of the wonders of the internet. You find that people have spent years working on this, what you thought was a relatively small question. There's a lot of experts out there that you can call.
I would say that there's definitely a place for calling and interviewing, but it's a beat that skews toward reading. And there's a lot of information available, as David says, in the briefs and in the lower court opinions. And this may be an unusual journalistic beat in which really bearing down on the written materials can help you. Sometimes, though, the cases at first blush seem to present a really interesting question. The facts are really, interesting, grisly, disturbing. And it turns out what the Supreme Court wants to decide is a teeny-weeny question of, did this particular prisoner appeal in the right way, in the right time, in the right court, and you get lost in habeas procedure, and sometimes a case that initially looks pretty appealing turns out to be, in the term David and the rest of us in the Supreme Court press corps might say, unwritable.
All right, well, let's take an example, and if you could step out for a moment from your specific Supreme Court beat and approach this question as someone who generally covers appellate courts. Was it August, Federal Judge Shira Scheindlin issued a very significant decision in federal court in New York concerning the policies and practices related to New York stop and frisk. And I would ask if you could, step by step, if you would start, Adam, what would somebody who already, as we all know, this case is being appealed, this decision is being appealed, what would some journalist who is deciding to cover this story now, at this stage, to begin at the appellate stage, what should they be doing? And obviously, starting with reading the decision, but do they just read the briefs at this point? Do they go to the underlying plaintiffs in the case? Tell us.
So we're now talking about a much more common sort of journalism than what David and I do, because what David and I do is basically on a set schedule, you know what's going to happen, and what real journalists do when they cover the courts is they have to react on the fly to a case they might have been aware of, but they don't know that it's going to drop on a certain Tuesday, and all of a sudden you have to get up to speed. You said in passing, but I really want to bear down on it. The first thing you really need to do, and not every beat reporter does it because it's time-consuming, is to spend a couple of hours and really read the district court opinion with care. That case is sort of a special case because it has so much crime policy and sociology and racial issues running through it that here's a situation where you really want to put out calls to law professors, criminologists, defense lawyers, prosecutors, people in the civil rights community to try to get a sense of whether Judge Schindlin's empirical analysis or analysis of the facts is really right. And then as it starts to go up to the Federal Appeals Court, absolutely. You want to get on top of the briefs, and you really want to, again, spend the time. The journalistic impulse is often to pick up the phone and get someone to explain it to you. But really, to write with authority, you need to internalize and get it yourself and understand it yourself, and there's no substitute for careful reading.
Well, let me just try to repeat exactly what Adam said, because I had exactly the same view, which is that the first and most important thing to tell any journalist is read the opinion. Because I've been around journalists for a lot of years, and a lot of young reporters would think, there's a big decision came out, I need to write about it, I'm going to start calling somebody to explain it to them. And the difficulty with that is that you're calling somebody who knows about it, and you can't even ask a good question, and you don't even know when you're getting a good answer if you haven't read the opinion and sort of absorbed what's going on.
And sometimes you're doing it so fast that however smart they are, they will not have had time to read it, so they're shooting from the hip.
Yeah, so that's something you just should say over and over again. Spend some time reading before you start calling smart experts, because I must say, when I first started out covering the court in the 1980s, I remember my first instinct was, well, there are a lot of these great sort of con law professors who have been commenting on the Supreme Court for years. So what I should do when the court decides something is call up, I'm not going to name names, but call up one of these people and say, what do you say about this decision, or what do you think it means? And then I realized all I would get from people was basically their preferred spin. Some people thought about it this way, they had a very liberal view, some people had a very conservative view, and I wasn't doing much good by just calling them up and sort of parroting the one view or the other. I really needed to do the work myself and sort of understand what this is about, and then try to explain it and get some commentary. So, as Adam said, the example you chose is a really interesting, complicated question where there's the use of statistics to try to say what's the pattern of police practice here. And so I thought that's an opinion you really need to spend some time reading and thinking about, and then start calling some smart experts. And I try to look for smart, seemingly nonpartisan experts. You don't want to go to the people who necessarily have the strongest, either in this case, pro-police or anti-police view of that question. I would search for somebody who's a smart person who's interested in the subject but is not the person who's got the most ideological view of the matter.
And there's been a positive development since David's old impulse of calling, say, a Harvard law professor for comment, where there were a handful of people who would comment on every single case, and sometimes it was within their wheelhouse and sometimes not really. Now, with the rise of legal blogs that specialize in certain areas of the law, whether it's election law or patent law, or for our purposes, very interesting criminal sentencing, Doug Berman's sentencing law and policy blog at Ohio State, those people, Rick Hassan's election law blog, those people are basically nonpartisan, are basically just interested in getting up to speed on what's going on every single day. And the fact that they show their work to you before you might even think of calling them, so you can assess whether they're playing it straight, is a really positive development. So now in the very, very many niche areas of the law that we cover, there are experts whose work we know, whom we can turn to for comment and analysis.
All right, so let's talk about the appellate process, and in particular, David, I want to ask you first about what merits coverage, and specifically, what milestones during the appellate process, the filing of the appeal or the petition, the argument in the appeal. Obviously, the decision gets covered usually when it's a matter of general public importance, but when do you start covering, and when do you start reporting on cases?
I don't think there's speak for myself, there's no hard and fast rule on that. I think it sort of depends on the issue and sort of depends on how big a deal it is, how much it's. Take the example of the cell phones. That's an issue that I guess just recently got to the Supreme Court in a sense of a petition, but it's been one that was percolating out there because there have been a lot of conflicting decisions. I would be inclined, and I think some of my colleagues have, if you see an issue like that that's a constitutional issue, that is, what's the Fourth Amendment say about this, and the police and lawyers and judges have different views on it, I think there are times when I would like to write about an issue that's in the appellate court somewhere, but not even at the Supreme Court. Not often, but on occasion. And I know Adam has done the same thing. If you see a big issue, you might write about it early, because I'm sort of thinking, what's the smart reader, interested in? And I think they can make an interesting story. And then sometimes when the case actually arrives at the Supreme Court, I'll even write a story when an appeal arrives, or we follow the cases that are coming up before the court on the conference when they're going to decide whether to hear about it. I don't have any hard and fast rule about that, but I think you can sort of weigh in at different times depending on how interesting the issue is, and if it's a really interesting case, we may write about it 3 or 4 times, the fourth time being the final decision. I think if it's an interesting case, we almost always write about it at the time of the argument, because the oral argument is one way to sort of put a spotlight on an issue, that you can sort of make a little story out of it, because the attorneys go up there, they make their best arguments, the justices ask questions that 8 out of 10 times you can pretty much gauge what the court's going to do based on their questions. So I think we have a number of different shots at it, and I've done it different ways on all kinds of different issues.
So there are 3 generic meat and potatoes kinds of stories that we write, and I'm not convinced most readers read them very carefully. One is, yesterday the court agreed to hear. The second is, yesterday the court heard arguments in, and the third is, yesterday the court decided. And all of us do those cases, all of those stories, and they have value and they need to be done. But the kind of setup piece David was describing a second ago may be more valuable for the reader, because it's a little more thematic, you have a little bit more time to do it, you may construct it in a way that it makes it broader and easier to understand for the reader. A second kind of setup piece might be to go visit with a prisoner or someone, a middle school student who was searched because she was thought to have Advil, strip searched. And that kind of story, I find, gets a much bigger readership. And it also has the incidental but not insignificant benefit of educating me. Because if I write that cell phone story, a same-sex marriage story, something about a fresh challenge to the Affordable Care Act, if I write it, I can't help but understand it. And that means that when it comes time to do these other more generic cases, I will be writing with more authority. There's something about writing but we have readers who are engaged, maybe to the point of being pedantic. So if you go even slightly wrong in emphasis, not to say facts, you're gonna hear about it. So the act of writing it down in a way that you feel is bulletproof is actually an incredibly good education for the journalist. So the early stories can make a big difference in the quality of the later stories.
I think, David, And Adam, you were referring a recently filed petition in a case called Riley, is the cell phone case, if that's right.
That sounds right.
Yeah, I think NACDL actually just filed an amicus brief in that case, and obviously that's one where I don't think it would seem too difficult to get your consumer of news and information to understand the relevance to their life.
Actually, recently the court has had, and I think the DNA swabbing case that David mentioned, whether the police can put a GPS device on your car, whether the police, simply because you're arrested for a traffic offense, say, can look through a smartphone which now contains your entire life. These are cases now, part of a great run of cases, whether you can be forced to, if you're stopped on suspicion of drunk driving, whether the police can poke a needle in your arm. These cases are easy for folks to understand, which means they're great for us to write about.
Now, you did say, though, earlier that there are times when you feel it's very important, or I interpreted you to say it's very important to tell the story through the people, whether it's the people in the case or whether it's other people who would be affected by a ruling of the court in any particular case. And I'm wondering if you could flesh that out a little bit for us. Like, how do you take an issue that isn't necessarily so accessible to me as understanding that, well, there's a difference between opening a pack of cigarettes to look and see if there's contraband and starting to search through the data in my smartphone? If it's not something that's so readily understandable, what sorts of steps do you take to find that real-world story to get your readers to understand that this case actually is quite relevant to their lives?
Well, for the most part, but I wouldn't say this is a general journalistic rule, but for the most part, we're going to be dealing with the actual case and the actual facts and the actual case the Supreme Court has agreed to hear. When I used to cover the law more generally before I started covering the Supreme Court, I would spend a lot of time hunting around for that anecdote in a live case, but among hundreds, that really brings to life the issue, that doesn't skew it one way or the other, that makes it seem a puzzling, close case for the reader, but that really brings it to life. I think there's a reason why, even in a Supreme Court brief, the facts section comes first, because by the time you finish reading the facts, even before you know the details of the law, most judges, most justices are going to have a feeling about what the right outcome is likely to be. So how you present the facts really matter.
You know, I've actually thought over the years, the longer I've done this, is that the facts of a particular case don't often have much to do with what the Supreme Court is deciding. Early on, when I did this job, I spent more time trying to, ideally as a journalist, you want the person's actual dramatic story to then work its way up. And you mentioned a good one, the young girl at a school in Arizona who was strip searched by a principal who's looking for like two Tylenol pills or whatever. And the question is that an unreasonable search and seizure? Well, that's a story that, all of us can write, and it's very sort of gripping and it's sort of shocking. But I think that's actually the great exception. That, for example, a couple of years ago, the court had a case involving GPS devices in tracking people. And it was the plaintiff, as I remember, or the defendant, was a convicted drug dealer in Washington who'd driven around a bunch of nightclubs or whatever. And you would think, first of all, there's nothing particularly interesting about this guy's case. He was apparently involved in going different places and moving drugs and was involved in drugs. But when the case got to the Supreme Court, the 9 justices who you would think would not be particularly interested in this fellow's plight, and particularly the fact that a police officer could have followed this guy around on the street, in their view, suddenly this is a Big Brother and the surveillance state. Because, with computers and cell phones and whatever, there's suddenly the vision that the government could track all of us all the time, everywhere on the street. And the question is, at some point, does that mass surveillance or that intensive surveillance of all of us all the time really got their attention? And there was a 9-0 decision essentially reversing this fellow's conviction. But I thought that's a kind of case that had almost nothing to do with the defendant's actual situation. It was a focus on what's the big legal issue. So while it's best, it's ideal from a reporting point of view to have a situation where somebody's actual story tells the issue. And I think in a lot of criminal cases for young reporters and journalists around the country, that's what you're writing about, is that people who've been charged with crimes and there's a real doubt whether the person is innocent or guilty, and so you can really hone in on that case, and that's really what the story is about. Once you get to the Supreme Court level, it's much more an issue of some big abstract issue of law, and that a lot of times, just my experience has been that the actual facts of the case don't help you a whole lot.
Well, that's a very good segue, because I wanted to go into 3 specific cases, and
May I say just a second more about this case involving Antoine Jones? David's quite right. He turns out to have been guilty with or without this GPS evidence, and I think he's since been convicted. And the telling moment at the argument, and probably the way we framed our argument story, I think the first question from the Chief Justice to the government lawyer was, does this mean you guys could put GPS devices on our cars? And the candid answer, and the government is to be commended for its candor, was yes. At which point, I think we looked at each other and we said, I think this is 9-0. Because it's one thing if you put it on Antoine Jones's car. It's a wholly different thing if you put it on the Chief Justice's car.
And with that, let me ask you, though. So you get this 9-0 outcome, but it's not a 9-0 opinion. And so you have the job as the journalist reporting upon this decision to explain to the public exactly what the ramifications are. There were justices, I believe Scalia was one of them, who were really very concerned about the surreptitious installation by law enforcement on private property of this GPS, that is to say the car being private property. And you had discussion in the opinions that came down about the duration of the surveillance. How do you take cases where you have a majority, in fact here you have unanimity, but the unanimity in the outcome of that particular case is a cobbling together of different legal principles? How do I know what exactly the government can and can't do now with respect to GPS installation and surveillance after Jones?
Kind of you to remind us of this difficult one. Why don't you take that?
So there's really 2 pieces to it. One is relatively easy, and the other is one that was a source of some controversy in the day or 2 after our reporting on the decision. The relatively easy part is you just have to spend a little time with the decision. For the most part, the justices are good, clear writers. Justice Scalia, writing for 5 justices, says this is basically a question of property rights. Justice Alito, writing for 4 justices, says, no, this is really about your reasonable expectation of privacy, and there may be some point at which it's just too much information. And then there's a weird concurrence from Justice Sotomayor, where she goes with the majority and yet concurs and makes Alito's point except 10 times as strongly, so you don't really understand why the 5-4 wasn't the other way. But that you just sort out. That's just a matter of putting one paragraph after the other. The harder part was the court was a little fuzzy in saying precisely what it was deciding. And really, I think most of us got it right, but not as clearly as we might have written, that this wasn't a question about do the cops need a warrant. It was merely a question of does this kind of activity constitute a search at all. And in the aftermath of a lot of press reporting, there was some criticism that that little distinction was lost.
Well, I just thought that case was a great example of what I said about my 3 questions. What did they decide, and what's the legal basis, what does it mean? I thought all 3 of the questions in that case were tough, because on the one hand, they decided this was a search. I assumed they meant that this was an unreasonable or unconstitutional search, but there were 2 completely different rationales. Justice Scalia said it's unconstitutional, it's unreasonable because the police went over and attached this little thing to the fellow's car. And they sort of went on his private property, private space.
And so to illustrate a sort of counterfactual, let's assume, and this is not crazy, that the GPS device was already in your car.
Yeah.
The manufacturer installed it, and the police merely monitored that. For Scalia, you might get a different answer because of the happenstance of nobody went under the hood of your car.
Yeah, so if we're trying to write about this, I think it was unclear that day, and I must say, I think in my own mind, it's still unclear whether this was a big decision or a fairly small decision. Because if it was just, as we say, what Scalia decided, putting it on the car is a search, and most of the police don't need to do that anymore. They can track the cars together. Maybe the decision doesn't mean anything. But then, as Adam said, Justice Alito and Justice Sotomayor wrote these concurring opinions that basically raised this whole question about that it violates a sort of right to privacy, that you don't think when you go out every morning that the police are going to be tracking you everywhere you go, and they're going to do it for a month with no search warrant, no probable cause to believe you've engaged in a crime. That's sort of a scary thought. And Justice Alito didn't set a clear rule, but it was quite surprising to have one of the more conservative justices sort of saying this whole notion of mass surveillance or constant surveillance violates the Fourth Amendment. So that one was a really interesting case, and it was a very hard case to say what they had decided and what it means.
And there have been decisions now in the aftermath of it seeming to take the guts out of it because lower courts have said, okay, it's a search, but maybe you don't need a warrant. Maybe all you need is some kind of reasonable suspicion, which the cops might well have. On the other hand, some of the criticism of these recently released decisions from the Foreign Intelligence Surveillance Court have been quite critical of that court for not taking account of what many commentators think is a revolution in this area of a new way of thinking, as David was suggesting, about there comes a point at which, even though each individual piece of data may be okay to collect, there comes a point at which the sheer volume of data invades our privacy. And I think the court is going to return to that question in a way in these cell phone cases if they end up taking them.
You know, that was, I forget exactly what I wrote in the LA Times that day, but I thought the big picture was more interesting than the small picture, right? In other words, I thought it was more interesting that 9 of them, for different reasons, were really troubled by the idea of tracking somebody on the street than that it was significant to say going up to somebody's car and putting something on it is a search under the Fourth Amendment. Because you would have thought, based on the court's precedents back in the 80s, you know, everybody knows if you go out on the street, walk down the street, a police officer could follow you. If you get in your car, somebody could, you know, a plainclothes officer could follow you. You're on a public street. And the old doctrine was, if you're in public, you don't have a right to privacy. And so I thought that was the kind of case where the actual decision may have been relatively minor, but what was really interesting was the sort of big picture that 9 of them were troubled by the idea of constant surveillance by the government.
Very interesting. Adam, you said something in your most recent comment that I think is an important takeaway for aspiring journalists and young journalists. You made reference to cases that have come following the Supreme Court's rule in U.S. v. Jones. So I take it then reporting on the outcome of a Supreme Court case is not the end of the story. And for a journalist, it doesn't end there by any means.
A good journalist might follow how the ripple effects of these decisions. And the decisions often have predictions in them. The dissent will often say, oh my God, requiring crime lab personnel to testify about crime lab results will devastate the American criminal justice system. Well, if there is such a prediction, a good journalist, and I don't do enough of this, might want to, a year later, go out and look whether these terrible consequences have happened or not. And those kinds of follow-ons, if the court changes the pleading standard of how much you have to put into your initial complaint, people will say that's going to result in a lot of cases getting dismissed. It'd be a great idea to check that out. We don't do as much of it as we should, but properly done, there's yet another piece to Supreme Court coverage, which is not only your fourth paragraph, here are the predicted consequences, but maybe a year later to see how it actually plays out on the ground.
Well, I agree with that. I was going to say that that's what a good journalist would do, and I don't think either of us qualify on that measure, because it happens all the time, is that the court hands down decisions. There are various we think, and some people say, this is going to mean this, and the dissenters say it's going to have this bad consequence, and there's not enough follow-up stories to say, okay, a year or two down the road, how's that played out?
Worse yet, and here's something you really need to resist. An editor is likely to use a phrase like, "Can't we write this any bigger?" Is this is a decision about extending ideas about whether you get a new shot if your lawyer was no good, from the trial context to the guilty plea context. Is that going to make a huge difference in how criminal justice is administered in the U.S.? And you can call around, and somebody will give you the quote. This is the biggest decision since Miranda. And you should resist that. The editor wants it. It might be more likely to get on the front page, but your gut tells you that's overplaying it. It's not worth it for your reputation.
Let me move on to the second of the three cases I wanted to talk about specifically today. And Adam, maybe you can tell us and use it as a sort of case study to say how you went about reporting on Maryland v. King, the DNA collection case. And I do hope that you'll include in your answer, there's an article that you wrote after the Supreme Court decision where you juxtaposed a cite in the decision to an Innocence Project publication, or that is a publication by that was co-authored by the founders of the Innocence Project, and Kennedy's citing to that, and at the same time having a few years earlier ruled in what some might think is a contradictory way when it came to access to DNA testing for prisoners seeking to prove their innocence.
So I'm going to see if I can try to get all this straight, and David will help me. We got a jump on this case where the Maryland it's not the Supreme Court, is it? It's the Maryland Court of Appeals?
It functions as a Supreme
Yes.
Court, right?
So Maryland's highest court strikes down its law, which had allowed DNA testing, cheek swab testing, of people arrested but not yet convicted of serious crimes. And I think it's easy to understand that once you're convicted of a crime, you may lose some of your rights. But if you're merely arrested, you're still presumed innocent, and there's no question but that this is a search. So does the government, under the Fourth Amendment, which bars unreasonable searches, have the right to swab your cheek? Really interesting question. It gets to the court in a funny posture where Chief Justice Roberts, and this is unusual, before the court has agreed to hear the case, says, I think it's pretty likely we're going to agree to hear it, and I'm going to stay the decision. I'm going to block the decision. I'm going to let Maryland continue to do this stuff. So at that moment, you had a chance to sort of get this on the radar even before the court agreed to hear it, get a sense of the facts, and then at that point, because the chief had already predicted the court was going to hear the case, correctly as it turned out, you paid a lot more attention to the briefing at the petition stage, and the court agrees to hear it, and it's obviously an interesting case, and it was well lawyered in particular by a lawyer named Ken Shanmugam on behalf of Alonzo King. So you follow it, you go to the argument, and then you have a decision which is quite, I guess I'd say it's quite odd, because the majority decision, in a couple ways. The alignment of the justices was unusual. You see Justice Scalia, typically thought of as a conservative, in a whole run of cases in recent years, ending up on what might be thought to be the liberal side. And on the conservative side, Justice Kennedy, writing for the court, says, oh, you misunderstand. In fact, the Chief Justice kind of misunderstood. This is not about solving cold cases. This is like a fingerprint. We use this DNA to identify people. And identification is proper under the Fourth Amendment, but you need a reason to search somebody if you're trying to solve a cold case. And Justice Scalia, in a very, very vivid dissent, kind of disassembles Justice Kennedy's rationale and makes him look really intellectually dishonest, and maybe I'll say persuasively so, that, and this is true in general, but true in this particular case, as between Justice Kennedy and Justice Scalia, sometimes it's not a fair fight, because Scalia is a very, very sharp writer and legal analyst. So you have this decision. And then I wanted to explore a piece of it where Kennedy had written, kind of as an aside, but you know what, another reason to do it is this will help free the innocent. Because this kind of DNA testing, if it will get the right guy, might free somebody who's in prison wrongly convicted. And that has a kind of surface plausibility to it, although, of course, that DNA testing is available already, you would think. If the guy's in prison already and the DNA would clear him, you don't need to find the actual bad guy. All you need to know is that his DNA doesn't match. But in support of this idea, Justice Kennedy cited a book by Peter Neufeld and Barry Scheck and Jim Dwyer in a way that I thought was quite unusual. He took a little phrase, ... and then several sentences, and I pulled out the book, and it turned out there were 6 sentences that were separated by those 3 dots in a way that Neufeld and Dwyer both said completely altered the meaning of what they had written, and Dwyer said it had made word soup out of his writing. And I thought that was unusual, too, that at the Supreme Court you wouldn't have a level of intellectual honesty and diligence that would allow you to manipulate things in that way. Oh, finally, you mentioned that there seemed to be some inconsistency in Kennedy's views. Kennedy had voted to say, in a different case, that there's no constitutional right for someone who claims to be innocent to get access to DNA evidence that could prove his innocence. So the innocent person, the person claiming to be innocent, has no right to DNA testing, but the person presumed innocent and arrested can be compelled to give up DNA. And some people thought there was a tension between those two positions.
I thought that was an interesting example of the tension between 2 justices. Breyer and Scalia are conventionally thought of, conservative, liberal, but they have a very different approach. Scalia is a rules guy. He wants a clear, simple rule. And in this case, he said, you can search, if you're the police, if you have some reason to suspect, somebody have done something wrong. And if you bring somebody in on a burglary charge, you don't have any reason to suspect he's been involved in rape, so you don't have any reason to take the DNA to search for these other crimes. You know who he is. You don't need to identify him. So Scalia was just sort of offended that this rule didn't make any sense. Justice Breyer is a sort of balancer. With every case is, you sort of weigh in this case, you weigh the impact on privacy and against the balance of the state's interest. And his view was, well, come on, what could be a more minor search? You're standing there and they take a little mouth swab, and the government could potentially find this person is a mass murderer who we've just, and we don't want to let him go if in fact this person is. So the government had a very strong interest in so in his view, the word is unreasonable. His view was that this was a reasonable search. A year before, one of the bigger cases was the motorist in New Jersey who gets arrested for an unpaid parking ticket or something, fairly minor, and taken to 2 different jails and strip searched. And the question in that case was, is it an unreasonable search to take a motorist who's actually, we learned, wrongly convicted or wrongly held for an offense only involving like a $50 fine, subjected to a humiliating strip search? Well, in that case, there's a 5-4 majority that says, no, this search was okay, reasonable, with Justice Scalia and part of the conservative group saying, wait a minute, the purpose of this is to keep, dangerous people and weapons out of jails, so that's a good purpose, you can do it. And Justice Breyer writes a dissent saying, wait a minute, this is ridiculous. You've got a person, a white-collar person, a businessman, you're subjecting him to a strip search. That's an unreasonable search. I always thought in one of the sort of side issues in a lot of the Fourth Amendment cases is that the justices have a very different way of viewing how you decide what's an unreasonable search.
And we've seen in this last term over and over again, Scalia, when it fits into his idea of the rules, will often vote in favor of the criminal defendant. And Breyer, who's sort of a pragmatist, think, it's solving some crimes, it's not such a bad idea. We'll go the other way. So you see these ideological opposites switching places.
Before I move on to the third of the 3 examples, I want to make sure that I'm getting an important takeaway for our audience, which is that you don't come into these cases without knowledge of how these judges have ruled in similar cases on issues touching upon similar constitutional rights or the same constitutional rights as in the past. And that would seem to apply as well when someone, for example, is following a case before a panel of a Circuit Court of Appeals, right? You would want to familiarize yourself as a journalist with the prior opinions in this area.
It's harder to do, and in the Circuit Courts of Appeals, they typically sit in panels of 3, and you may not know until fairly late in the game who it is, and they don't necessarily have the same kind of track record of chewing over these same issues over and over again. But in a perfect world, yes. We have the luxury of seeing all 9 of them sit over and over again and basically look at variations on a relatively small number of themes. So when we go in to hear a case, and when the lawyers brief a case, they have a pretty good idea of the commitments that these justices have already made. They hate to seem hypocritical. So it's very often the case that even before argument, you have a pretty good idea of how they're going to vote, and after the argument, you have a very good idea how they're going to vote.
I think to some degree the Supreme Court is a little more like today, that the Congress is like today compared to what it was 30 or 40 years ago. 30 or 40 years ago, I've been reading a book about how they handled the death penalty cases in the 1970s. During all that period, there were 2 or 3 or even 4 justices that were sort of moderate conservative, moderate liberal. And on the big cases, you couldn't tell where Byron White or Potter Stewart or Lewis Powell and then John Paul Stevens were going to come out. Congress used to be like that. You remember when there were Republican senators who were moderate to liberal and Democratic senators who were moderate to conservative, and it was there was a lot more play in the middle. And the Supreme Court's becoming more like that, that on more cases, on more big issues, you can pretty much gauge where they're going to be. And on the big issues, as you know, that Justice Kennedy is the sort of, he's with the conservatives on about 2/3 of the big questions, and he's with the liberals on about 1/3 of the big, and they're almost not a surprise, because Kennedy's got a series of views that he's relatively consistent on, except that they don't fit the ideological pattern. But most of the other justices, most of the days, if you go there and listen to an argument, you have a pretty good sense, as soon as you walk into the room, how they're going to view it. And one of the fun things in the arguments is when they don't play true to form.
And I would pick up in a tangential way, but I think also an important tip. David mentioned the book he's reading. It's called A Wild Justice.
A Wild Justice, yes, very good.
Reading around, not necessarily case specific, but just general background. If you want to be a legal reporter, there's a lot of good judicial biography, case histories. I just finished a biography of Byron White. I'm reading a book about Holmes's First Amendment jurisprudence called The Great Dissent. A lot of it written for a popular audience, and you never know when it's going to be handy to help you put in context some of these issues, so you're not bearing down on some narrow slice of the Fourth Amendment, but you're also seeing it in some broader context.
So, David, some people walked away from the last term of the Supreme Court thinking, wow, so after one of the dog sniff cases, my home is more protected than my DNA from the Maryland v. King case. And some of our viewers may have watched you moderate a panel at the National Press Club on C-SPAN last year that NACDL sponsored on these 2 dog sniff cases, Florida v. Harris and Florida v. Hardines. I believe it's pronounced Hardines. Can you tell us about what you did to prepare for covering those stories and about those cases in general?
You mean beyond coming to NACDL to talk about them?
Absolutely.
Well, these are 2 fun cases because, again, there's sort of in a category of cases we talked about where everybody can sort of imagine what's involved here. In the one situation, you're driving on the road and you're stopped because your headlight is out, or your license plate is, your registration is out of date by a month, and the officer says, I want to sniff around in your car to sniff if there's any drugs. And apparently the law is if FIDO alerts, then the officer then can go in your car. The other case was a situation where the police took a dog, Frankie, up to, the attorney who was arguing that case was kind enough to come out. We talked to him on the front steps, and he had little photos of the dog.
An adorable chocolate lab, and we put the picture in the paper every chance we got.
Yeah, I kept him on my desk for the whole term. And so in that case, which turns out to be significant because it got Justice Scalia's view of property, the dog was taken right up to the front porch of some fellow's house, and he alerted or sat down or whatever, and sure enough, the home was growing marijuana inside. So I read about the background of those cases. The Florida Supreme Court, in both cases, had reversed and had taken a very strongly, pro Fourth Amendment view, which is to say, in the car case, how do we know these dogs are reliable? I did a lot of reading on this case and was actually surprised. I sort of assumed that 99% of the, if a dog alerts, there's something there. It turns out, though, that there's a lot of evidence that dogs react to their master's cue. And so the danger would be if the officer brings around Fido and sit to the back of the car, I'm going to make a made-up name here, Fido.
Aldo.
I don't want to make Aldo as the guilty party here. But let's a generic dog, Fido, comes around the back. He may alert just because the officer brought him there. There was actually some studies that I read about in the briefs where a woman had set up a study at UC Davis with a lot of trained police dogs from Northern California, and they were told that in these 3 rooms of this old house, there's going to be 4 or 5, I forget what the number was, of marijuana or something hidden. Well, sure enough, the dogs go in, and each one of them hit 4 or 5 different spots and alert. Turns out there was no marijuana in them. The dog handler, and some reason, the dog ended up cueing on a series of little things of where the marijuana was hidden. There was no marijuana there. So the Florida Supreme Court did something that I hadn't seen before, which is they actually didn't trust the reliability of the dogs. And so their rule was they were going to actually require the police and the prosecutor to show some evidence that this dog has been trained and has gone through some independent testing where he actually, we can be confident that when that dog alerts, he's actually alerting on a smell. He's not alerting in response to the dog handler. But the Supreme Court, in the first case, a 9-0 ruling where the Elena Kagan wrote an opinion that says a sniff is up to snuff as long as any reasonable person would think the dog's.
Right. And moreover, I know you're trying to protect Aldo, but as I recall, Aldo once alerted and there was nothing in the car.
Yes. And the second time, Aldo stopped this same car and there was nothing in it. Now, I guess
the police say, but maybe there was before, the smell's still there.
Yes, that's right. Aldo, you can always get off by saying Aldo was detecting the scent of something that had been in the car. So, anyway, so in that case, they came out with a ruling that says trust the dogs on the street, on the highway, but Justice Scalia, a 5-member majority, said, don't bring that dog up to my front. By the way, that was another situation where you could see the justices, well, what if they brought this dog up to my front porch?
Yes.
Could they actually bring a police dog up on my front porch and just sit there and sniff around?
Wow. Well, I have just a couple of more questions, and they're of a more general nature. I'd like to get both of your reads on this. When you are taking in news, reading it, watching it, listening to reporting on criminal justice matters in the courts, and in particular in the appellate courts, what are you looking for that distinguishes better journalism from the rest? And in that vein, you could also incorporate, please, some of the pitfalls for journalists to avoid. I know one of them that's happened in any number of appellate cases is the rush to report and not necessarily getting the holding right. Adam?
I read just about everything written journalistically about the Supreme Court, and the writing I admire, and the press corps is very strong and very collegial. The writing I admire is the stuff that helps me understand a difficult issue. And, it's hard. Some of this stuff it takes a while for it to sink in about just exactly where the tension is, just exactly what the issue is. Factual accuracy, of course, is very, very important. And then, you try to make sure that you don't miss anything on your beat. It's not a huge beat, and the paper really relies on me, and David's papers rely on David, to know what's going on. And I would say, probably you're different in this, I find Twitter to be reliable. If you do hashtag SCOTUS and you glance at that every once in a while, even if some quirky little thing happens, it'll come up on your radar.
Well, one of the things that I think is important for journalists writing about criminal cases and whatnot, one of the things that has bothered me at times is to read a story in some publication about someone that I think, wow, this person was wrongly convicted and must be innocent. Because those are stories, that my eye is drawn to them and I want to read them. And then I go back and look at a lower court opinion or something and realize that the writer of the story didn't include a lot of the facts or evidence that caused the police either to arrest this person or the jury to convict them. So I think it's important always in writing about criminal cases or any type of cases is give a fair shot at the facts on both sides, because criminal cases have two sides to them, and there are plenty of stories where the police and the prosecutors are wrong, but it's important to at least give the readers a full picture about what happened and why this person was convicted. So that doesn't play in a whole lot of Supreme Court cases, but I must say, just as reading it, it's one of the things I'd always like to tell young journalists: don't get so carried away with your view about what actually happened here that you leave out entirely the evidence that sort of goes the other way.
Right, and I find this is an issue with editors because there's so much talk of innocence that they really only care about innocence, but you should also care about wrongful conviction of guilty people. That the justice system should be just, and people shouldn't be allowed to take shortcuts. And sometimes you need to educate editors to say, not every single person is innocent, but even a guilty person deserves a fair trial.
Well, I've learned a great deal today, and I'm sure our audience has as well. I want to wrap up with an open-ended question to both of you, which is, if we haven't covered any advice, guidance, or tips that you would like to provide to journalism and communication students, young journalists, aspiring criminal beat reporters, that we haven't covered, now would be a great opportunity.
There's no substitute for writing, for exercising that muscle, for finding a forum in which to write a lot, because you get better as you do it. In our little part of the world, to my great surprise, people from unorthodox backgrounds have really busted into the broadly speaking Supreme Court journalism community simply by starting blogs, writing books. I'm thinking about Mike Sachs, who's now at the Huffington Post, used to be a Georgetown law student, and he came up with this idea he'd have a blog called First One at One First, One First being the address of the Supreme Court, and he'd try to be the first guy in line for all the big arguments. And he'd write it up, and he paid attention, and he occasionally had an insight. Sean Hopwood, a former bank robber, now a law student and soon to be a D.C. Circuit clerk, just pays attention to the court, writes interesting things, and has made something of himself. Josh Blackman, a George Mason law student, now a young law professor, wrote a book about the Affordable Care Act litigation. None of them come from the conventional background of journalism or even of fancy lawyers, but simply by doing it, by writing a lot, by trying to have insights and fresh points, there are ways into this business that are not the usual track of starting, nor was mine, but starting at the Kansas City Star and working your way up and becoming a legal reporter that way.
Yeah, I think that's very good advice. On the one hand, the sort of web is destroying or knocking down some of the mainstream media, as everybody knows, because they're taking away the audience. But the good side of that story is that there's a whole new audience in all sorts of new ways, and so there are ways for people, if you get interested in an idea or a subject or an issue, people can get involved in blogging about it, writing about it, as that young guy Josh did, just writing. He got involved in following the Affordable Care Act, followed it all the way along, and made a really fine book out of it. So, Adam's absolutely right. There's a lot of ways to get into journalism and writing about courts and law that are new in different ways, and there are still opportunities for that.